Representative Hoppe, House File 3994. Would you like to move your own bill?
Thank you, Madam Chair. I would like to move House File 3994.
Very good. And do you want to do amendments first, or do you want to walk through the bill?
Madam Chair, I think it's easiest to take the delete all amendment first, and then
All
we
right.
can walk through the bill, and I have a celebrity testifier.
Okay. Wow, awesome. Okay, I understand that the DE2 is on its way here.
Well, Madam Chair, in light of that, maybe we could start taking questions from the committee, and I could have my esteemed testifier start explaining the bill and why we're here with it.
All right. Why don't we have the testifier go ahead and walk through the bill as to why it's here and walk through what the bill does, so we kind of get an overview of an understanding on the bill. Go ahead. Welcome to the committee. Please state your name for the record.
Thank you, Chair Scott, and members of the committee. My name is Joel Leviton, and I'm a partner at the Stinson Leonard Street Law Firm. I represent Bremer Trust, the court-appointed administrator of the estate of Prince Rogers Nelson. I am here to provide testimony on why the legislation before you, recognizing a post-mortem right of publicity, is a far better option than allowing Minnesota law to remain silent on the issue. The right of publicity is a property right that allows individuals to control the commercial use of their own name, image, and likeness. For example, the use of your name in an advertisement. Case law has held that Minnesota recognizes a right of publicity. What is not clear, however, is whether the right of publicity exists following death. 17 states recognize by statute a post-mortem right of publicity that transfers to a decedent's heirs after death, including California, Tennessee, Illinois, and Washington. Since most property rights survive beyond death, allowing this transfer to heirs is consistent with other property rights. The right of publicity may be addressed in someone's will and be transferred to one or more devisees. If a decedent does not address it in a valid will, and the decedent state recognizes a post-mortem right of publicity, state law can direct how that right of publicity transfers following death. Which brings us to the estate of Prince Rogers Nelson. For better or worse, Prince is the first Minnesota celebrity to reside here, to pass away here, and likely go through probate with a right of publicity that has value. At this point, we are not aware of any will. The lack of clarity as to whether the right of publicity exists after death will further complicate an already difficult probate process, perhaps delaying the proper inheritance for heirs. The value of a celebrity's rights in his or her name and likeness can change with use and can change over time. Without clear legal protection prohibiting unauthorized commercial uses of Prince's name and likeness, the asset, that is Prince's identity itself, begins to diminish in value as others use it for commercial purposes. There is no way that a subsequent court case can fully recover the value for Prince's heirs. There are just too many people who can sell T-shirts and merchandise with Prince's image. The best and clearest resolution to this issue is to update Minnesota statutes to make three things crystal clear. First, that Minnesota recognizes a right of publicity. Second, Minnesota joins 17 other states specifying the statutory right of publicity extends after death. And third, when a will does not address this right of publicity, it will be treated like any other asset that the decedent owns at death. The law is not intended to address only Prince's estate. It would apply to all Minnesotans. The clarity this law provides will allow all people to prevent unauthorized commercial uses of one's name and likeness during life and following death, and will make it clear that the right of publicity is part of a decedent's estate. I will close with the following. Like other states that have a statutory right of publicity, there are exceptions to the prohibition. Most notably, an exception for the news media, an exception for commentary and criticism. Nothing in the bill would prevent a newspaper from writing a story about Prince or a television station from running a news story about Prince. The bill is designed to address unauthorized commercial uses like merchandise. I'd be happy to answer any questions.
Thank you. Thank you for your testimony. What I'd like to do is have staff go through the DE2, if that would be all right.
I have a question.
Representative Lesh?
Thank you, Madam Chair. My question for the testifier is, what about that little yin-yang glyph? Does he own that, or did he own it at the time, or if someone wants to put that on a T-shirt, does that qualify as name or likeness?
Mr. Levison?
Chair Scott, thank you for the question. Yes, I think that would qualify as Prince's likeness in that particular situation. And then I would add that in that situation, that's probably protected by trademark law as well.
Okay, well,
Representative Lesh?
do you know for a fact that, you don't know for a fact that it is protected by trademark, but I guess, so likeness isn't just their image or their name, it's something closely associated with him as well?
I think
Mr.
that-
Levinson?
Thank you. I think that's correct. Likeness would be anything that would identify a person. And in this particular situation, I do think that symbol identifies Prince.
Okay, thank you, Madam Chair.
Thank you. All right, Ms. Mullen, if you want to go through the DE2, please.
Chair and representatives, I'm just going to take you quickly through the DE2. This creates a new section in Chapter 604, a right of publicity. Subdivision 1 contains a definition for photograph. Subdivision 2 lays out the cause of action for a right of publicity, and it indicates, starting at 1.10, the types of situations where you couldn't use an individual or deceased individual's name, voice, signature, photograph, or likeness. That section also indicates that an action must be related to an individual who is domiciled in Minnesota or was domiciled here at their time of death. Subdivision 3 starts on the top of page 2, and that's the damages section. It lays out the types of damages that can be awarded, as well as reasonable attorney's fees and costs. Subdivision 4 indicates the injunctive relief that can be obtained in a case like this. Subdivision 5 provides specific rights related to the publicity of a decedent, and kind of like what Mr. Levinson said, it indicates how the rights of publicity pass after an individual has died. Subdivision 6 starts on page 3 at line 4. These are fair use exceptions. These are situations where, like, the news is reporting on a person. This allows for news, public affairs, sports broadcasting, commentary, and criticism as an exception to the right of publicity. Subdivision 7 is the commercial sponsorship. This allows for the individual's publicity rights, the name, voice, signature, photograph, and likeness, to be in a medium that also has sponsorship and advertising. The example that was used was a magazine, and so it's a question of fact as to whether or not there's a nexus between the individual's name, voice, signature, photograph, or likeness and the actual advertising that occurs. Subdivision 8 is immunity for the medium of publication. So this is the magazine, the radio, a billboard owner who publishes something when they don't know that the use of that likeness was unauthorized. So it provides an exception for them. Subdivision 9 links this with Chapter 333, which is the state trademark and insignia chapter. Subdivision 10 allows this to be cumulative with other legal and equitable remedies. And the final part is the effective date at 3.28. And it allows this to apply to cause of action that is brought on or after August 1 of 2016.
Thank you, Ms. Mullen. And before we get to public testimony and then member questions, Representative Hoppe, would you like to move your amendments? And I will bring to members' attention, there is a, where did it go? The DE, or not the DE, the A2 amendment. I did contact Representative Lesh earlier. This was filed after the 8 o'clock deadline? 8 o'clock deadline this morning, and it just kind of cleans up some of the language that refers, if I'm not mistaken, back to the fair use exceptions. Would that be right, staff? Ms. Mullen?
Chair and representatives, this amendment does two things. When the DE2 is drafted, some internal references were changed, so this updates the internal references Where it says subdivision 1, it should say subdivision 2. So it makes those changes. It also inserts a second provision into the fair use subdivision at 3.4. And this is a exception that allows the use of a person's likeness when it is in certain things, plays, books, literary works, films, motion pictures, television programs, and things like that.
Okay, great. Is there an order that we have to take these in? Okay, all right. Okay, we're going to start with the A2 then, Representative Hoppe, I've been advised, and I will waive the notice period on, for amendments.
No objection, Madam Chair.
Thank you, Representative Lesh.
I did have another question for the testifier.
Yep. On this amendment?
Well, could be asked later. Go
Okay.
ahead, Madam Chair.
All right, thanks. Let's get the amendments and get the bill in the shape the author wishes, then we'll move forward. I will move the A2. Any discussion on the A2? Seeing none, all those in favor of the A2, please signify by saying aye.
Aye.
Opposed, same sign. The A2 is adopted. The A2 is amended, let's see, I guess the next order of business is the DE2. Any discussion on the DE2? Seeing none, all those in favor of the DE2, please signify by saying aye. Aye. Opposed, nay. The D2 is adopted. Is there also? All right. Representative Lesh, I'll let you have a question here, and then we're going to see if there are any testifiers in the audience. Go ahead.
Thank you, Madam Chair. My question is for the testifier again. So your answer to my last question made me think of some articles that I had read about brands that had tried honoring Prince on Twitter after his death. One was that famous Chevy ad with the little red Corvette on it, and it said, "Baby, that was much too fast." Think of it, that ran in the New York Times for Chevrolet. Would that be implicated under the terms of this bill?
Mr. Levitin.
Madam Chair, member, thank you. I'm not familiar with that particular advertisement, but if it was a commercial advertisement that ran on television, I would say yes. I would also add that what this law would do, it would clarify that this right of publicity exists after death, and it's something that the estate can control and those who benefit from the estate can control. Whether they intend to object to certain uses or permit certain uses, that would be in their discretion. But if it was a commercial advertisement, I think, yes, it would fall within the purview of the law.
Okay.
Representative Lesh.
Well, and that's why I asked, because I think I understand that you asserted that this already exists in common law in Minnesota, and we're codifying it. So under the terms of common law in Minnesota, would the family currently have a claim against Chevrolet for running that ad? And just to describe it for you, there's a back shot of a Corvette, an old like 60s Corvette. The bottom of the page, it says, "Baby, that was much too fast." It says 1958 to 2016. Yeah, that's it right there. Representative Hoppe's got it. So under current terms, the family or the estate would have a claim against Chevrolet for running this. Is that true?
Mr. Levitin.
Thank you, Madam Chair. Well, whether the family would have at this point, it's not clear who the heirs are. I'll say that just to be clear. I think the answer would be arguably yes. They would have a claim if this invokes Prince's image and likeness, and this isn't a commercial advertisement. I would say yes. And there is some case law from other jurisdictions having to do with Michael Jordan's image in sort of similar contexts, and in those cases they have found that those do infringe upon the right of publicity.
Okay. Thank you, Madam Chair.
Is there anyone in the audience wishing to testify for or against this bill? Wow. All right. I'll open up to further member questions then. Anyone have questions? Representative Pinto.
Thank you, Madam Chair. So one question relates to the length of the the right, because it's 50 years, but it really just keeps on going as long as the heirs continue to use, to have this right. It's 70 years for copyright, and I'm wondering what the rationale is for the length of time specified in the bill.
Mr. Levitin.
Madam Chair, member, thank you for your question. We looked at a variety of states that have this postmortem right of publicity, and we tried to find something that was fair. So, for example, Indiana has a 100-year right of publicity. California has a 70-year right of publicity. Tennessee has one that can go on indefinitely. If there's continuing commercial use of one's name and likeness, it can go on forever. And so we thought starting with 50 would be fair and would be consistent with other states. And if there is a continuing use of it without any gap, then it could go for another 50 years. So for a total of up to 100 years.
Representative Pinto?
Thank you, Madam Chair. And just, I guess, broadly, what is the purpose of, typically with intellectual property, right, we grant rights in order to, like we grant a copyright to encourage people to create works, intellectual property. With trademarks, we want to make sure that we avoid confusion for consumers. What is the purpose of having this particular property right exist in intellectual property?
Mr. Levitin.
Madam Chair, member, thank you. The purpose is really, it's a personal right, that individuals have their right to control how their name and likeness is used. So it's a personal property right that is really inherent in the individual, as opposed to a consumer protection right, like a trademark right. So we really view it as a personal property right that continues to exist, and that allows the rightful heirs to benefit from the commercial value that was developed in that name or likeness during the lifetime, and not have it be exploited by unauthorized uses.
Representative Pinto?
Thank you, Madam Chair. I guess what's the purpose of the 100-year limitation then? I mean, if somebody inherits a piece of jewelry or something, right, we don't after 100 years say, well, you had this, but now we're taking it back. Because as I understand your answer, it's focused on sort of inherent personal rights. You know, this is, you have a right to your own name, likeness, et cetera. So I'm just trying to understand the distinction there.
Mr. Levitin?
Thank you, Madam Chair. The distinction is to not overreach, to recognize that this can come to an end, and there could be a period of time where a right of publicity turns into a trademark right, and that trademark right could potentially continue to exist as a standalone right, but there may not be, for a period of time, trademark rights, and so the right of publicity would allow heirs of a descendable right of publicity to build that right of publicity into a trademark right, which potentially could continue to exist. But it was, to answer your question, it's really to be practical and to just to have an end date.
Representative Pinto?
Thank you, Madam Chair. And what is what's the need to get this accomplished in these couple weeks? I guess maybe one question I have is, how long do you expect that the settling of the estate will take? I guess I would expect it would take until, at least another year, I would think. So I gather there is a rush in your view to get this done in the next couple weeks, and so what is that rush?
Mr. Levitin?
Madam Chair, member, thank you. The rush is that we have to, as counsel for the special administrator for the estate, have to assist with administration of the estate and ultimately have tax issues to deal with within a 9-month time period following the date of death. And what we would like to have clarified is that this right is part of the estate. And not have to wait until next year, and certainly not have to litigate that issue to see whether it is part of the estate, so we can really administer the estate in a more orderly fashion.
Representative Pinto?
Nothing further.
Thank you. Any other member questions for this testifier? Representative Lesh?
Further question. Thanks, Madam Chair. And Representative Hillstrom was pulling up a bunch of images of all the different ways Prince was honored in the wake of his death. And it made me wonder about what other ways, because as I understand the answer to the question, name and likeness is more expansive than what I had imagined. But the buildings downtown that lit up their buildings purple, purple's identified with Prince. Now it's a color in the spectrum too, so I assume no one can own a color. However, it is definitely identified with Prince, and they were lit up specifically in the wake of his death to honor him, and many of these were commercial businesses that did so. Would those be implicated under the name and likeness terms of the bill?
Mr. Levitin.
Madam Chair, thank you. In my view, no, they wouldn't. I don't think the color in and of itself would implicate the right, and I wouldn't consider that to be a commercial use in an advertisement.
Representative Lesh.
Okay, thank you, Madam Chair.
Any other member questions? Representative Schoen.
Madam Chair and Representative Hoppe, or the testifier, are there any states that have like a time frame? For instance, that ad, we'll take the Corvette ad, or not even ad, just in memoriam. It was kind of neat. And it's not like they made T-shirts. So if it was just one ad and it wasn't an ongoing and it was a certain amount of time, or you think that the color wouldn't suffice, but maybe an unscrupulous attorney could decide to bring action on behalf of someone anyway. And if it's not a permanent thing, like a T-shirt or a sign or a hat, are there states that have time frames, like say within 48 hours of something, or maybe that doesn't even exist? But like, for instance, the unfortunate demise of Representative Hoppe and I wanted to take out an ad in the paper with his likeness, then, or get T-shirts, one of the two. Would I be able to do so with it? Are there states that would give me 48 hours to do that and be okay?
Representative Hoppe.
Well, Madam Chair and Representative Schoen, I would expect both the ad and the T-shirts in the event of my unlikely demise. I thought that'd be funnier. I think the distinction is when you look at the ad, I was struck by the ad that GM did when they had that out the day after Prince passed away. I think the difference would be they did that at one time in memoriam, and I thought it was very tastefully done. That's my opinion. I'm a non-attorney. I think the difference would be if they decided to start selling T-shirts at every Chevrolet dealership in the country, and I think that's the kind of thing that we're after here, that then they would have to, talk to the estate and make sure that that was licensed, and I'm sure they would do that. In terms of years, I don't know what other states have done. I'll turn that over to the expert.
Mr. Levitin.
Thank you, Madam Chair. I am not aware of any state saying you have to bring a cause of action within 48 hours of the ad running. But I will say, practically speaking, under the proposed statute, there would be you would be entitled to actual damages and you'd be entitled to an injunction. And your remedies there may not be any remedies that you really need at that point, right? Because you don't need an injunction because the ad is not running anymore, and the actual damages would be minimal because it was a one-time thing. So practically speaking, I wouldn't view that as a very attractive case, if you.
Representative Hillstrom.
Thank you, Madam Chair. So we saw on the side of a building Prince's face and his symbol was painted in Minneapolis. If this were to become the law, would the family be able to order that to be taken down? It's my understanding that it was not for profit. Would the family be able to order that be removed?
Mr. Levitin.
Madam Chair, thank you. In my opinion, no, it would not. That would be a single commercial, a single work of art, an original work of art, and I don't think that falls within the scope of the statute, in my opinion. The tributes out at Paisley Park and that people are making, I don't think that falls within the scope of this. This is really designed for people selling merchandise bearing someone's name and likeness.
Representative Lesh.
Thank you, Madam Chair. So I've got another question. Now, I know that Elvis's estate has very effectively protected their trademark of Elvis merchandise, but I'm pretty sure that a diner can sell a fried peanut butter and banana sandwich without getting in trouble, and that a shoe store can sell blue suede shoes without having an issue. But I'm willing to bet that there probably have been items litigated previously on behalf of the estate. Can you tell us, are there any court cases out there that set that line of demarcation with respect to the likeness, with some outstanding fact patterns that let us know, okay, what are people going to be able to do after this and what are they not going to be able to do? And granted, these are court cases specifically to maybe Elvis or some other celebrity, but can you maybe enlighten us of where the line would be on this?
Mr. Levitin?
Madam Chair, thank you. A case that comes to mind is a case involving Michael Jordan's likeness with an advertisement where the number 23 and a pair of shoes appeared, and the ad said something like a shoe-in for the Hall of Fame. And his name was not used, but the number 23 was determined to identify his likeness. So that would be an example of a case where you're not explicitly saying someone's name, but it was still held to be a likeness.
Representative Hoppe?
Thank you, Madam Chair. And Representative Lesh, this might be going back a little bit to previous questions, but anything that was done, the Eiffel Tower, skyscrapers in Sydney or downtown Minneapolis or 3M, whatever it was, none of that would apply under this law because this would be anything from August 1st this year going forward. And I think one more thing on that GM ad, whoever at GM came up with that and had it in the New York Times the next day, that's pretty good thinking. I mean, I assume they had a nice promotion or bonus or something. That was, I thought, a really nice ad in there rather quickly.
Representative Lesh?
Madam Chair, and I know that the GM ad was universally lauded, but in the same article I saw a lot of others that were not universally lauded. Cheerios changed their logo to purple and then put a little Cheerio over the print sign or something. I can't remember. It was kind of lame. And then Pixar changed the I to that glyph. Is there a name for that glyph, by the way? Should I be calling it a glyph? I'll just call it the glyph.
Mr. Levitin, do you know what the name of that thing is?
Madam Chair, I am not familiar with the name.
And then, in fact, Pornhub changed the P to the glyph. So I guess I'm assuming there would be a lot of folks maybe who the estate would could potentially bring claims against. But Representative Hoppe, my understanding is that this currently exists in common law. So despite the fact that the effective date isn't until August, theoretically, provided the will had gone through probate at everyone, and we know who can assert the claims on this, the law is currently applicable under common law. Is that right?
Representative Hoppe?
Madam Chair, Representative Lesh, that is my understanding. But again, I mean, I think this is going to take a while for everything to go through probate, and I would be surprised if there's any reaching back for, a purple Cheerio or anything else.
Okay. Thank you, Madam Chair.
Any other member questions? Seeing none, I'll renew my motion. Oh, I'm sorry. We do have a couple more testifiers. Mr. Amundson, and then if there's an Elizabeth Mature in here. Welcome to the committee.
Thank you, Madam Chair. Members, Mark Anfinson, attorney for the Minnesota Newspaper Association. I apologize to both you, Madam Chair, and the members for not being here earlier. I had a conflict, and I regret that. I'll be very brief, 5 minutes at the most will be my comments. The concept of the bill is something we don't oppose. The right of publicity, which is the right to control somebody else's commercial use of your name or likeness, is well recognized. And it's actually, as Representative Lesh points out, been recognized in Minnesota for 17 years under the common law. The concern we have, and we want to just briefly express to the committee, is that the execution of the concept as expressed in this bill has a number of serious flaws. And the good news is we have plenty of time to talk to people and work all those flaws out, or maybe not. And the speed of the bill's progress is really our concern. These things can all be worked out. This has been done in other states. The question is whether we have time to adequately do it. Publicity rights involves a very complex group of legal issues, okay? This is not a simple concept, and the more you look at this, the more complex the issues get. And ultimately that complexity has a direct impact on First Amendment rights, on the rights of free expression. Everything that you place within the scope of publicity rights, you take away from the scope of the First Amendment and free expression. So you have to be careful about how a bill like this is structured. And it creates, ultimately, if you're not very careful with the execution, as opposed to the good idea, it creates a pretty substantial weapon. And that weapon will eventually be picked up, not by well-meaning folks, but, well, let's take an example, by people maybe like the Jesse Venturas of the world, who will protect and defend their claim that somebody else has used their name, their image, their likeness improperly. And guess what? Then you have the pleasure of litigating at very serious cost whether or not this law applies to them. And so my appeal to the committee is there be some time to work this out. Now, how do you do that in 2 weeks? You can't. Talking to Mr. Levitin, as I did yesterday, my understanding is the main concern that the trustee has involves post-mortem publicity rights. It would be fairly easy, I think, if I can propose that, as just a suggestion, to adopt legislation that makes clear that Minnesota's current protection under the commercial appropriation doctrine for publicity rights would continue past death, and that the right to the publicity would be descendable, would be something you could put in a will, and that could be inherited by a person's heirs. And if you did those two things, I think you would accomplish a lot of the present concern. There's no real need, in other words, to adopt the rights of publicity in their entirety with all their complexity this year. You can come back in future sessions and do the rest. So, thank you, Madam Chair. I appreciate, again, your indulgence of the timing here.
Thank you, Mr. Anfinson. Any member questions for this testifier? I appreciate your words of caution, and I would just urge the author and the testifier to take that to heart, and if there's some changes that you think need to be made, I think we need to address that too. So.
And Madam Chair, if I can say, the author and Mr. Levitin have been very responsive in being willing to discuss this, so I appreciate it.
Great. Thank you
Thanks.
for your testimony. Elizabeth Mature, welcome to the committee. Please state your name and title and to go ahead with your testimony.
Chairman Scott and members of the committee, thank you for the opportunity to be here today. My name is Elizabeth Motter. I am Director for State Government Affairs with the Motion Picture Association of America. MPAA is the trade association for the leading producers and distributors of filmed entertainment across all media, from motion picture theaters to home entertainment to pay cable and satellite networks to over-the-air broadcast networks to the internet. Our member companies include Disney, Fox, NBC Universal, Paramount, Sony Pictures, and Warner Brothers. We at the Motion Picture Association of America have a long history of working with actors and other Screen Actor Guild members to both protect their personas and likenesses and at the same time protect the First Amendment rights of authors, creators, and other artists to produce their works in the way they see fit. We believe the expressive works exemption now contained in this bill strikes that important balance, and we are happy to have had the opportunity to work with Prince's estate to achieve this mutual goal. This bill is now consistent with similar bills enacted all over the country, most recently South Dakota's right of publicity law, which was enacted last year in 2015. Thank you for the opportunity to be here today. I'm happy to answer any questions.
Any questions for this testifier? Seeing none, thank you for your testimony. Thank you for being here today. Any other member questions before we go to a vote? Seeing none, all those in favor of passage of House File 3994 to the General Register, please signify by saying aye. Aye. Opposed, same sign. The bill is passed and on its way to the General Register. Thank you for being here today.
Thank you, Madam Chair and members.
Thank you.
Thank you, Madam Chair.